Before we begin, a quick and important disclaimer. This video provides a historical analysis of the legal profession and matrimonial law in early 20th century America. The content presented here is strictly for educational and entertainment purposes and does not constitute modern legal advice, professional career counseling, or financial guidance. Historical trends and case studies discussed should not be interpreted as predictions of future results in current legal proceedings. Law is a jurisdiction-specific and evolving field. Viewers are strongly encouraged to conduct their own due diligence and consult with a licensed professional regarding any personal legal matters or career decisions in the legal industry. In 1915, if you were a resident of New York seeking to end a suffocating or abusive marriage, you didn't just need a lawyer. You needed a playwright, a private investigator, and a professional liar. At the dawn of the 20th century, the United States was a patchwork of contradictory moral codes where getting a divorce was essentially a high-stakes theatrical production staged for a judge who was often looking for any reason to deny the petition. If you failed to follow the script, or if the court suspected you and your spouse actually agreed to the divorce, the case would be dismissed for collusion, and you would remain legally shackled for life. This was an era where the divorce attorney was viewed not as a standard pillar of the bar, but as a shadowy figure operating in the matrimonial underworld, navigating a system designed to make exit impossible. This deep dive into the historical trends of early 20th century litigation reveals how a desperate American public and a handful of opportunistic lawyers transformed the legal landscape from a rigid moral fortress into a multi-million-dollar industry. By the end of this masterclass, you will understand how the tactics forged in the smoke-filled offices of 1920s Reno and the divorce mills of the Midwest laid the groundwork for the modern billion-dollar family law apparatus. For the modern viewer, this is more than just history. It is a roadmap to understanding why our current legal system remains fundamentally adversarial, and why the business of heartbreak became a cornerstone of American civil law. To understand the problem this solves for you today, we must look at the fault-based system that governed the early 1900s. Unlike the no-fault laws common today, an individual in the early 20th century could not simply state they were unhappy. They had to prove a crime or a moral failing. In most states, particularly New York, the only recognized ground for divorce was adultery. This created a massive problem for the average American. What do you do if your spouse hasn't cheated, but the marriage is still dead? This is where the specialized divorce attorney stepped in. These were the fixers of the Gilded Age. They didn't just argue points of law, they managed the raid. The raid was a meticulously planned event where a lawyer, a private detective, and a photographer would burst into a hotel room to catch a spouse in a compromising position. Often these scenes were entirely staged. The other woman was frequently a professional correspondent, hired by the attorney to sit on a bed in a slip while a flashbulb popped, providing the necessary evidence for the court. Case studies from this period, such as the 1906 Special Report on Marriage and Divorce by the U.S. Census Bureau, show a staggering shift in potential outcomes for those who could afford these specialized services. Between 1887 and 1906, nearly 1 million divorces were granted in the United States, a number that shocked the moral guardians of the era. The report highlighted that cruelty and desertion were becoming the primary vehicles for legal separation in states with slightly more relaxed laws, like South Dakota and Nevada. For the American audience today, understanding this history reveals why prenuptial thinking and asset protection became such vital concepts. Back then, property was almost always awarded to the innocent party. If the attorney could prove the other spouse was at fault, they could effectively strip them of their wealth and social standing in a single afternoon. The role of the attorney was further complicated by the migratory divorce phenomenon. Since New York law was so restrictive, attorneys began marketing divorce colonies to wealthy socialites. If you had the means, your lawyer would advise you to move to Sioux Falls, South Dakota, or later Reno, Nevada. You would establish a temporary residence for 3 to 6 months, stay in a divorce ranch, and then appear before a local judge who was far more sympathetic to the commercial benefits of a thriving divorce industry than the moral strictures of the East Coast. This was the birth of the divorce mill. Attorneys in these jurisdictions were pioneers of legal marketing, often meeting trains at the station to hand out business cards to newly arrived pilgrims seeking freedom. They were the first to treat the law as a service-based commodity, a trend that continues to define the legal profession in the 21st century. However, the risk for these attorneys was immense. Throughout the 1920s, the American Bar Association and various Committee of 14 groups frequently targeted matrimonial lawyers for disbarment, accusing them of unprofessional conduct, and manufacturing evidence. A step-by-step look at a typical 1910 divorce file reveals a level of forensic detail that would baffle a modern clerk. The attorney had to document every hour of a spouse's movement, provide corroborated testimony from disinterested witnesses, and navigate the interlocutory decree, a waiting period, usually 1 year, between the trial and the final judgment. This year was a legal purgatory where the lawyer had to ensure their client didn't do anything that could be interpreted as reconciliation, which would instantly void the entire case. Data from the era suggests that the cost of such a procedure was prohibitive for the working class. In 1920, a contested divorce in a major city could cost upwards of $500 in legal fees and investigator costs, roughly equivalent to $15,000 today. This created a two-tiered system of justice, one for the elite who could afford the Reno cure and the staged hotel raids, and another for the poor who were often forced into poor man's divorce, which was simply desertion. This historical trend explains the deep-seated American obsession with equal access to justice that would eventually lead to the legal aid movements of the mid-century. Furthermore, we must examine the specific strategies used by attorneys to handle the collusion trap. Under the law of recrimination, if both parties were found to be at fault, for example, if both had committed adultery, neither could get a divorce. The law viewed marriage as a contract that could only be broken if one party was a saint and the other a sinner. Attorneys had to coach their clients to appear perfectly aggrieved, even if they were secretly desperate to leave. This forced the legal profession into a state of institutionalized hypocrisy. Lawyers became experts in subterfuge, a skill set that, while controversial, allowed thousands of people to escape truly abusive situations in an era before domestic violence was widely recognized as a legal cause for action. As we move deeper into this series, you will see how these early 1900s shysters, as they were often called, actually became the accidental architects of modern civil rights. By pushing the boundaries of what a contract meant, and by forcing the courts to accept mental cruelty as a valid legal claim, they slowly eroded the Victorian-era grip on the American family. This part of our masterclass establishes the foundation. The divorce attorney of 1900 was a social pariah, a legal magician, and a necessary evil in a society that refused to admit that some marriages simply fail. For the U.S. audience watching this today, this historical perspective is essential. It proves that the adversarial nature of your local family court isn't a glitch in the system. It is a feature designed over a century ago during a time when the law preferred a lie to a clean break. We are going to look at the specific case of the Vanderbilt divorce next, to show exactly how much power a 1920s attorney could wield when the stakes involved the greatest fortunes in American history. To understand the true power of a 1920s divorce attorney, we have to look at the legendary legal maneuvering surrounding the Vanderbilt family, specifically the 1926 annulment of Consuelo Vanderbilt and the Duke of Marlborough. This case serves as the ultimate historical trend in high-stakes litigation because it demonstrated that for the right price, an attorney could not only end a marriage but effectively delete it from history. In 1926, the legal team behind this case had to navigate a minefield of international law, the strict requirements of the Catholic Church, and the scrutiny of the American press. The strategy wasn't just to prove the marriage was unhappy. The goal was to prove it never legally existed by arguing coercion. The attorney's role here was to orchestrate testimony from the Vanderbilt matriarch, Alva Belmont, who admitted on the record that she had forced her daughter into the marriage. This was a radical legal gambit. It required the attorney to convince the court that a marriage of 30 years, which had produced heirs, was void from the beginning. Imagine if today, in 2026, a lawyer tried to argue that a 30-year partnership was a legal fiction because of a conversation that happened 3 decades ago. In the early 20th century, this was the pinnacle of elite legal advocacy. It showed the American public that the divorce attorney was the ultimate gatekeeper of social status and personal freedom. While the ultra-wealthy used these sophisticated annulment strategies, the average American professional, like a fictionalized John Doe in 1924 Chicago, faced a much grittier reality. Imagine if you were John Doe, a rising executive who found himself in a marriage that had become a cold, silent prison. In 1924, you couldn't just walk into a courtroom and cite irreconcilable differences. Your attorney would sit you down in a wood-paneled office, heavy with the scent of tobacco, and explain the step-by-step mechanics of the staged raid. This was the bread and butter of the matrimonial bar. The attorney would hire a professional correspondent, often a young woman from the fringes of the acting world, whose job was to be found in a hotel room with the husband. The script was always the same. The attorney, a private investigator, and a photographer would burst through the door at a prearranged time. The husband would be caught in his shirt sleeves, the woman would hide her face, and the flashbulb would pop. This single photograph served as the indisputable proof of adultery required by the state. This wasn't just a legal tactic. It was a flourishing sub-industry. Case studies from the era show that a specialized attorney would have a Rolodex of these professional witnesses who were paid a standard fee, often between $10 and $20, to perform this role. The risk was enormous. If the judge suspected the raid was staged, the attorney could face disbarment for suborning perjury. Yet, historical trends show that thousands of these cases were processed every year, with judges often turning a blind eye because the legal fiction was the only way to provide relief in a rigid system. The financial data from this period reveals just how lucrative this business was for the attorney. In 1926, a standard contested divorce in a city like New York or Philadelphia would involve legal fees that could easily exceed $2,000 when you accounted for the detectives, the witnesses, and the court costs. In today's 2026 economy, that is roughly equivalent to $35,000. This created a potential outcome where the attorney was effectively the primary beneficiary of the marital dissolution. The lawyer became a master of the shakedown, using the threat of a public, scandalous trial to force a quiet, expensive settlement. For the wife, Jane Doe, the attorney's strategy was often built around the concept of alienation of affections. If Jane could prove that another woman had stolen her husband's love, her attorney could sue that woman for damages. This was a powerful leverage tool. The attorney would use these secondary lawsuits to squeeze the husband for a larger alimony settlement. A deep dive into the legal archives shows that these alienation of affections suits were often used as a precursor to the actual divorce filing, serving as a tactical nuclear strike that destroyed the husband's social standing before he even set foot in divorce court. This brings us to the complex legal theory of the migratory divorce and the exploitation of the full faith and credit clause of the U.S. Constitution. This is the masterclass level of understanding the early 20th century legal landscape. Attorneys realized that while New York was a fortress of restriction, other states were businesses. The attorney's job was to navigate the conflict of laws. If John Doe lived in Manhattan, his lawyer might advise him to establish a domicile in Reno, Nevada. To do this, John had to follow a strict step-by-step process. Move to a Nevada ranch, stay there for exactly 6 weeks, surrender his New York driver's license, or the 1920s equivalent of residency markers like bank accounts, and then file for divorce in a Nevada court. The genius of the attorney lay in the legal argument that under the Constitution, New York was required to recognize the judicial acts of Nevada. However, this was a massive legal gamble. If the New York attorney could prove that John Doe never truly intended to live in Nevada, and only went there for the divorce, the New York court could declare the Nevada divorce a fraud. This led to the famous Williams versus North Carolina cases, which eventually reached the Supreme Court. But in the 1920s, it was a wild west of legal uncertainty. Attorneys were essentially selling their clients a ticket to a legal gray zone where they were divorced in one state, but potentially still married in another. The role of the private detective in this era cannot be overstated. The divorce attorney and the private eye were an inseparable pair, often sharing office space or operating under a profit-sharing arrangement that would be highly unethical today. These detectives weren't just following people. They were agents of the attorney tasked with creating leverage. They would wiretap telephones, which was a new and legally murky technology in the 1920s, sift through trash and bribe doormen for information. The goal was to find the one piece of dirt that would make the other party settle. Case studies show that many attorneys used these detectives to engage in shadowing, for months at a time, documenting every single person the spouse met. If the attorney could find evidence of even a single dinner with a member of the opposite sex, they could build a case for inclination and opportunity, a legal standard that allowed a judge to infer adultery even without a hotel room raid. This psychological warfare was the hidden engine of the early 20th century legal system. It turned every divorce into an intelligence operation, where the attorney acted as the lead strategist. As the decade progressed toward the late 1920s, the legal marketing for these services became increasingly bold. Attorneys in Reno and Sioux Falls began placing advertisements in national magazines, promising a civilized solution to marital woes. They were essentially the first to market law as a lifestyle product. They coordinated with divorce ranches that offered luxury accommodations for the 6-week residency period, effectively creating the first legal tourism industry in American history. These lawyers weren't just arguing cases, they were managing entire ecosystems of hospitality, transportation, and legal paperwork. This shift marked the beginning of the end for the old moral guard. The divorce attorney was no longer just a fixer in the shadows, they were becoming a visible, if still controversial, part of the American economic fabric. But as this industry grew, so did the backlash. Religious groups and conservative lawmakers began a crusade to close these divorce mills, leading to a series of high-stakes legal battles that would determine whether the state or the individual had the final say over the American family. What these crusaders didn't realize was that the attorneys were already 10 steps ahead, developing a new legal weapon that would bypass the need for hotel raids and Reno ranches altogether. This was the rise of the separation agreement, a document so legally potent that it could effectively end a marriage without a single day in court, provided the attorney knew how to hide it from the prying eyes of the king's proctor. But how did they keep these secret agreements from being flagged as illegal collusion? And what happened when a lawyer was caught playing both sides of the fence in a $1 million estate battle? The answers lie in the secret manuals and private correspondence of the era's most successful matrimonial firms, which we will uncover in the next part of this deep dive. We are moving from the hotel rooms of New York to the desert ranches of the West, where the law was being rewritten by the hour, and where one mistake could land an attorney in a jail cell instead of a courtroom. To understand the perilous legal tightrope walked by attorneys in the mid-1920s, one must grasp the concept of the separation agreement. In an era where the state actively sought to preserve the sanctity of marriage at all costs, any agreement between a husband and wife to end their marriage was legally considered a conspiracy against the state. This was called collusion, and if a judge detected even a hint of it, the case was tossed out and the attorney risked facing charges of barratry or professional misconduct. Imagine if today, in 2026, a lawyer could be sent to prison simply because both parties agreed that their partnership was no longer working. In 1927, this was the reality. The divorce attorney's secret weapon was the carefully crafted property settlement. On its face, the document appeared to be a routine division of assets, houses, stocks, and family heirlooms, but between the lines, it was a roadmap for an uncontested divorce. The attorney had to ensure the language never suggested the parties were cooperating to get a divorce. Rather, it had to state they were settling their affairs because they were already living apart. This required a linguistic gymnastics that only the most elite matrimonial lawyers mastered. They would use phrases like "for the purpose of avoiding further litigation," or "to provide for the support and maintenance of the parties in their current state of separation." If the wording was even slightly off, the king's proctor or a state-appointed investigator could intervene, claiming the parties were making a mockery of the law. The stakes shifted dramatically when the focus moved from the restrictive courtrooms of the East Coast to the dusty, opportunistic landscapes of the West. This was the birth of the Reno Cure. In the late 1920s, Nevada realized that divorce was not just a legal matter, but a significant economic opportunity. Historical trends show that as other states tightened their moral belts, Nevada loosened its residency requirements. By 1927, the residency requirement was 3 months. By 1931, it would drop to a mere 6 weeks. This created a massive influx of legal work that necessitated a new type of attorney, the high-volume, cross-jurisdictional specialist. These lawyers were essentially logistics managers. They didn't just file papers. They coordinated a client's entire life for 3 months. Imagine a character named Evelyn Thorne, a wealthy socialite from Philadelphia in 1928. Her local attorney would contact a corresponding counsel in Reno. Together, they would manage her move. Step 1 was the establishment of a bona fide domicile. Evelyn couldn't just stay in a hotel. Her attorney would advise her to rent a cabin or stay at a dedicated divorce ranch. This was a critical legal detail because the attorney had to be able to prove in court that Evelyn had an intent to remain in Nevada indefinitely, even though everyone in the room knew she was leaving the moment the decree was signed. The divorce ranch was a unique American phenomenon where law met hospitality. Attorneys often held silent partnerships in these ranches, creating a closed-loop system of revenue. Case studies of ranches like the Flying Me or the Pyramid Lake Ranch show that attorneys would personally visit their clients at these locations to prepare them for their 3-minute hearing. The hearing itself was a masterpiece of efficiency and rehearsed testimony. The attorney would ask a series of rapid-fire questions. Have you resided in Washoe County for the required period? Do you intend to make Nevada your home? Has your spouse committed acts of extreme cruelty? The client would answer yes to each, and the judge, often processing dozens of these cases a day, would grant the decree. The attorney's fee for this 6-week orchestration could range from $500 to $5,000, a staggering sum at the time. For the attorney, the potential outcome was a high-profit, low-risk practice, provided they could keep the client from admitting on the record that they only came to Nevada for the divorce. However, the legal danger remained back in the client's home state. This is where the concept of the migratory divorce became a battleground of constitutional law. If Evelyn Thorne returned to Philadelphia with her Nevada decree, her husband's attorney could challenge its validity in Pennsylvania court. The historical trend in East Coast litigation during this period was to declare these Western divorces as mail-order frauds. The Philadelphia attorney would argue that the Nevada court lacked jurisdiction because the residency was a sham. This led to a two-front war for the matrimonial lawyer. They had to be a master of Nevada procedure while simultaneously being a constitutional scholar capable of arguing the full faith and credit clause before a hostile judge in the East. This specific legal friction is why the divorce attorney of the 1920s was often viewed with such suspicion. They were perceived as agents who helped the wealthy bypass the moral laws of their own communities. To protect their clients and themselves, attorneys began implementing a strategy known as the affidavit of service by publication. In many cases, the spouse who remained in the home state would refuse to sign any papers. To get around this, the Nevada attorney would place a small, obscure legal notice in a local Reno newspaper for several weeks. If the spouse didn't respond, and they rarely saw a newspaper from 3,000 miles away, the attorney could claim they had been legally served and the divorce could proceed by default. This was a brutal legal maneuver that often left the abandoned spouse with no recourse. It was a cold-blooded application of procedural law that favored the party with the financial means to travel. This era of the law was not about justice or equity, it was about the technical mastery of residency and service. Data from the late 1920s indicates that the divorce rate in Reno was nearly 10 times the national average per capita. This volume allowed attorneys to refine their processes to a degree never seen before in American law. They created standardized forms and checklists that allowed them to handle hundreds of cases simultaneously. This was the industrialization of the legal profession. But this efficiency brought increased scrutiny from the American Bar Association. In 1928, a major investigation was launched into the ethical practices of lawyers specializing in these migratory cases. They were accused of advertising, which was strictly forbidden, and of facilitating perjury regarding residency intent. The attorneys fought back by framing their work as a necessary service for a changing society. They argued that if the law was out of step with the people's needs, it was the attorney's duty to find a way through the thicket. The pressure on these lawyers was immense. They were the ones who saw the reality of failed marriages every day, the alcoholism, the physical abuse, and the financial ruin, which were often hidden behind a veneer of Victorian respectability. An attorney in 1929 might be handling a case where a woman had been deserted for 5 years, but couldn't get a divorce in her home state because she couldn't prove her husband's adultery. For that lawyer, the Reno system wasn't a scam, it was a lifeline. But the line between providing a lifeline and running a legal racket was razor thin. Some attorneys began taking it a step further, offering guaranteed results by bribing local clerks to backdate residency affidavits. This was the dark side of the industry, where the matrimonial lawyer transitioned from a strategist to a criminal conspirator. As we moved toward the 1930s, the stock market crash would change the economics of divorce entirely. Suddenly, the wealthy socialites who funded the Reno ranches were broke, and attorneys had to find a way to serve a middle class that was increasingly desperate for legal relief, but had no money to pay for it. This led to the rise of the discount divorce mill, and a new wave of legal innovations that would shock the nation. But even more dangerous than the financial collapse was a new, rising threat: the emergence of organized crime families who realized that the divorce industry was a perfect front for money laundering and extortion. If you think the staged hotel raids were scandalous, wait until you see what happened when the mob decided to take a seat at the council table. We are about to look at the intersection of the legal bar and the criminal underworld, and how a few ambitious lawyers almost lost their lives trying to balance the two. The next part of this dive reveals the secret ledger of the 1930s divorce attorney, where the price of freedom was sometimes paid in more than just cash. The entry of organized crime into the American legal landscape during the 1930s was not a sudden invasion, but a calculated infiltration of a system already weakened by the Great Depression. By 1932, the high society divorce ranches of Nevada were seeing a decline in their traditional clientele of steel magnates and oil heiresses. The economic collapse meant that even the wealthy were counting their pennies, and the divorce attorney had to find a new, more aggressive revenue stream. This is where the historical trends take a dark and dangerous turn. Organized crime syndicates, particularly in cities like New York, Chicago, and Detroit, realized that the matrimonial courts were the perfect environment for a high-level shakedown. The divorce attorney became a pivotal figure in what was known as the Badger game, but refined into a legal art form. In this scenario, a mob-affiliated detective agency would identify a wealthy target, perhaps a businessman who was still solvent despite the crash. They would then employ a female operative to lure the target into a compromising situation. But unlike the 1920s raids, which were often staged with the consent of both spouses to bypass restrictive laws, the 1930s raids were frequently used for pure extortion. Imagine if you were a businessman in 1934, trying to keep your company afloat in the midst of the worst economic crisis in history. You find yourself in a hotel room with a charming woman, only for the door to be kicked in by a man claiming to be a private investigator, accompanied by a lawyer who immediately presents you with a choice: a quiet, incredibly expensive settlement, or a front-page scandal that would destroy your remaining credit and social standing. This was the intersection of the legal bar and the criminal underworld. The divorce attorney in these cases wasn't just representing a client. They were acting as the collection agent for the syndicate. The fees weren't just for legal services, they were a tax on survival. These lawyers maintained secret ledgers where the price of a client's freedom was often split 3 ways: one share for the firm, one for the detectives, and a significant kickback to the local political machine or crime family that provided the protection and the targets. To see the data behind this corruption, we have to look at the Seabury investigation of 1930 to 1932. Samuel Seabury, a former judge, was tasked with rooting out corruption in New York City's magistrates' courts. What he found was a pipeline of exploitation that shocked the U.S. audience of the time. The investigation revealed that a specialized group of divorce attorneys had formed a symbiotic relationship with the vice squad of the New York Police Department. The step-by-step mechanics of this racket were chillingly efficient. Cops would arrest women on trumped-up charges of prostitution or immoral conduct. These women, often innocent and terrified, were then steered towards specific lawyers. These attorneys would then contact the women's husbands or families, offering to provide the evidence needed for a quick divorce in exchange for massive sums of money. If the husband refused to pay, the lawyer would threaten to have the wife imprisoned. If the husband did pay, the lawyer would ensure the evidence was presented in court in a way that granted the husband a fault-based divorce, stripping the wife of any alimony or property rights. This wasn't just a legal practice. It was a state-sponsored kidnapping and extortion ring, facilitated by the very people sworn to uphold the law. This historical case study highlights a potential outcome of a legal system that prioritizes moral judgment over factual reality. When the law makes it impossible for people to end a relationship honestly, it creates a vacuum that is inevitably filled by predators. The Seabury investigation led to the disbarment of dozens of attorneys and the resignation of several judges, but it also exposed how deep the rot had gone. For the modern viewer in 2026, it serves as a stark reminder of why legal transparency and the separation of the judiciary from political influence are so critical. In the 1930s, the divorce attorney was often the only person who knew where the bodies were buried, sometimes literally. While the shakedown lawyers were operating in the shadows of the big cities, a different type of legal innovation was happening for the middle class: the rise of the $50 divorce mill. As the Depression deepened, the average American could no longer afford the multi-thousand-dollar fees of the 1920s. Attorneys began to industrialize their practices, offering budget services that streamlined the process of proving fault. They would use professional witnesses, who would testify in multiple cases a day, often wearing different hats or glasses to avoid being recognized by the same judge. These lawyers were the first to use what we might today call lead generation tactics. They would scan local newspapers for news of marital strife or domestic disputes and send runners to the homes of the aggrieved parties to pitch their low-cost services. This was a direct violation of the American Bar Association's ethics rules against solicitation. But in a world where lawyers were also struggling to buy bread, many felt they had no choice. These discount mills relied on the concept of uncontested fault. The attorney would draft a complaint alleging extreme cruelty, a broad legal term that could mean anything from actual physical violence to habitual coldness. The other spouse, who also wanted out, would be coached by the same attorney or a friendly colleague not to contest the charges. This was a form of collusion light. The risk for the attorney was that if the judge asked too many questions, the whole house of cards would collapse. However, data from the era shows that as court dockets became overwhelmed with debt collection and bankruptcy cases, judges were more likely than ever to rubber-stamp divorce decrees just to clear their schedules. The divorce attorney of the 1930s became a master of procedural velocity, learning exactly which judges were the most lenient and which clerks could be incentivized to move a file to the top of the stack. But even as these mills made divorce more accessible, the danger of the criminal underworld loomed. Mob families started using these high-volume law firms as a way to launder money from Prohibition-era bootlegging and the emerging gambling rackets. A law firm is an ideal front. It deals in high-value, intangible services where the value of an hour of work is subjective. An attorney could record a massive fee from a client who didn't exist, effectively cleaning the syndicate's cash. This brought a new level of violence to the profession. If a lawyer tried to go straight or withheld money from their silent partners, the consequences were not a reprimand from the Bar Association, but a ride in a black sedan. We are now entering the most explosive era of this history. As we move out of the Depression and into the 1940s, the world goes to war, and the American family is fractured on a global scale. The divorce attorney is about to face a tidal wave of cases from returning GIs and war brides that would change the law forever. But before the dust could settle on the 1930s, one final scandal would emerge. A case involving a stolen inheritance, a forged will, and a divorce attorney who tried to double-cross the most powerful mob boss in Chicago. This single case would lead to a change in the way legal ethics are taught in every law school in the country. In the next part, we will look at the war room tactics of the 1940s and the secret proxy divorces that were granted to soldiers while they were still on the front lines of Europe. How did a lawyer manage a client they couldn't even talk to? And what happened when those soldiers came home to find their lives had been legally dissolved without their knowledge? The era of the legal ghost is next. The transition from the shadow of organized crime in the 1930s to the global upheaval of the 1940s created a unique legal vacuum that necessitated the rise of the legal ghost. As millions of American men were deployed across the Atlantic and Pacific theaters, the domestic legal system faced a crisis it was never designed to handle. This period marked a massive shift in historical trends regarding matrimonial law, as the physical absence of one spouse became the defining feature of thousands of cases. The divorce attorney of this era had to become a specialist in the Soldiers and Sailors Civil Relief Act of 1940, a piece of legislation that was intended to be a shield for those in uniform but which quickly became a chess piece in the hands of a clever litigator. This act was designed to prevent civil legal proceedings from moving forward if one party was on active duty and unable to defend themselves. However, the potential outcomes for those seeking a divorce often depended on how aggressively their attorney could navigate or circumvent these federal protections. Imagine if you were a soldier named Michael Smith in 1944. You are stationed in a mud-caked trench in Italy, your mind focused entirely on survival. Back in Ohio, your wife Sarah has decided that the marriage was a mistake made in the heat of a pre-war romance. She goes to a local attorney who specializes in what was then called wartime dissolution. Under the 1940 Act, the court was supposed to stay or pause the proceedings, but the attorney would implement a step-by-step strategy to move the case forward. Step 1 was the solicitation of a waiver. The attorney would draft a legal document that sounded remarkably patriotic and innocuous, then mail it to the soldier on the front lines along with a Dear John letter. The soldier, overwhelmed by the chaos of war and the emotional blow of the letter, would often sign the waiver just to make the pain go away, not realizing they were signing away their rights to property, future earnings, and even custody of their children. This was the first iteration of the legal ghost. A person whose legal existence was being erased from a distant continent while they were physically fighting for their country. In cases where the soldier refused to sign, the attorney would pivot to more clandestine tactics. This led to the era of the fraudulent affidavit of service. The historical records of the mid-1940s show a suspicious number of cases where attorneys claimed they had conducted a diligent search for the missing spouse and were unable to locate them. This allowed the court to proceed by publication, placing a small notice in a local paper that the soldier would never see. The attorney would then present a default judgment to the judge, effectively divorcing the soldier in absentia. These were the true legal ghosts. Men who would return from the war in 1945 or 1946 only to find that they were legally single, their bank accounts were emptied, and their homes had been sold. This created a social and legal catastrophe that flooded the American courts during the post-war years. Data from the United States Census Bureau highlights the magnitude of this shift. In 1940, there were roughly 264,000 divorces granted in the U.S. By 1946, that number skyrocketed to an unprecedented 610,000. This spike represents the largest single-year increase in the history of American divorce until the mid-1970s. For the divorce attorney, this was a period of high-volume processing. The masterclass in 1940s litigation involves understanding the concept of the divisible divorce. This was a legal theory developed during this era to handle the jurisdictional chaos. It meant that a court could grant a divorce to end the marital status, the legal bond, but might not have the power to decide on property or alimony if it didn't have personal jurisdiction over the absent spouse. Attorneys had to be experts in splitting these issues into different legal buckets, often leading to decades of follow-up litigation once the soldiers returned. As the U.S. domestic courts became clogged with these complicated cases, a new industry emerged south of the border: the Mexican divorce mill. For those who didn't want to wait for the 3-month or 6-week residency requirements in states like Nevada, attorneys in cities like El Paso, Texas, began acting as brokers for the courts in Juarez, Mexico. This was a radical expansion of the legal ghost phenomenon. A client could hire a lawyer in Texas who would then coordinate with a Mexican attorney. Through a series of powers of attorney, the marriage would be dissolved in a matter of days without either party ever setting foot in Mexico. This was often marketed as a quick and painless solution, but the historical trends show it was a legal minefield. Many U.S. states refused to recognize these mail-order divorces, leading to a new class of legal ghost: the unintentional bigamist. A person would get a Mexican divorce, remarry in the U.S., and then find out years later that their first marriage was still legally valid. The attorney's role in these Mexican cases was essentially that of an international paper shuffler. They would charge high fees for what was often a very flimsy legal product. Case studies from New York and Illinois in the late 1940s show hundreds of instances where these divorces were struck down as frauds on the court. However, for the attorney, the immediate financial outcome was lucrative. They were selling a commodity, freedom, to a public that was desperate to move past the trauma of the war. This period also saw the emergence of the proxy marriage, where soldiers were married via telephone or radio, which only added to the complexity when those same couples sought a divorce months later. The attorney had to prove that a marriage that had never been physically consummated or even physically attended was legally binding before they could even begin the process of tearing it down. Imagine if you were a legal professional in 2026 looking back at the case of a soldier who found his wife had remarried 3 days after a Mexican decree was issued. The lawyer in that scenario had to balance the ethical duty to the client with the high probability that the decree would be overturned. Many attorneys justified their actions by pointing to the sheer demand. The post-war American society was in a state of flux, and the old moral standards were crumbling. The attorney was no longer just a fixer. They were a social engineer helping to dismantle the Victorian family structure in favor of a more modern, albeit more chaotic, individualist model. The psychological toll on the attorneys of this era was also significant. They were the ones reading the desperate letters from the front lines and the cold, calculated instructions from the home front. They were the ones who saw the human cost of the legal ghost. In one historical case study from 1947, an attorney in Los Angeles was actually sued by a returning veteran for what was essentially professional negligence in facilitating a ghost divorce. The case revealed a network of lawyers who were coordinating with real estate agents to sell off veterans' properties while they were still overseas. This scandal forced the American Bar Association to tighten its rules on service of process, but the damage was already done for thousands of families. As we move into the 1950s, the era of the legal ghost would evolve into something even more pervasive: the era of the suburban secret. The focus of the divorce attorney would shift from the battlefields to the newly built Levittowns in suburbs across America. The tactics used to dissolve marriages would become more subtle, involving the early use of psychological evaluations and the weaponization of the newly emerging field of child psychiatry. But just as the legal profession was settling into this new suburban rhythm, a new threat emerged that would change the divorce landscape forever: the televised divorce trial. The first celebrity divorces were about to be broadcast to the nation, and the lawyers who handled them were about to become household names. We are moving from the foxholes to the bright lights of the early media circus, where a lawyer's reputation could be made or destroyed in a single soundbite. In the next part, we will uncover the secret strategies of the first celebrity divorce attorneys, and how they used the new medium of television to manipulate public opinion and pressure the courts. We are about to enter the world of the high-profile shakedown, where the courtroom was just a stage for a much larger drama. The transition into the mid-1950s saw the American divorce attorney evolve from a backroom fixer into a sophisticated architect of public perception. This was the era of the suburban secret, where the newly minted middle class lived in the manicured landscapes of Levittown and the sprawling developments of the Sunbelt. On the surface, the nuclear family was the bedrock of national stability during the Cold War. But underneath that veneer, the legal industry was grappling with a surge in what was then termed domestic dissatisfaction. The attorney of the 1950s had to be more than a litigator, they had to be a master of the invisible settlement. Because the social stigma of divorce remained incredibly high, particularly for professional men and women in the burgeoning corporate world, the goal was often to resolve the matter before a single document was filed in the public record. This led to the historical trend of the midnight negotiation, where attorneys would meet in private clubs or secluded offices to hash out agreements that would never see the light of day. For the American public today, looking back from 2026, it is difficult to grasp just how much power these lawyers held over a person's social and professional life. A single misstep in a public filing could result in a man being fired from his firm or a woman being ostracized from her community. Imagine if you were a rising executive named Richard Thompson in 1955. Your attorney wouldn't just ask about your assets. They would ask about your neighbors, your boss, and your standing in the local country club. The step-by-step strategy for a 1950s suburban divorce often began with a quiet separation disguised as a long-term business trip or a health retreat. The attorney's role was to provide the legal cover for this absence while simultaneously negotiating the division of the suburban dream: the split-level home, the station wagon, and the college funds. If the negotiation turned sour, the attorney had a new and devastating weapon at their disposal: the psychological evaluation. This was the era where psychiatry entered the courtroom in a major way. Attorneys began collaborating with mental health professionals to prove that a spouse was mentally unstable, an alcoholic, or unfit for parenthood due to neuroses. This wasn't just about winning a case. It was about pathologizing the opposition to gain total control over the narrative. Case studies from this period show a marked increase in the use of terms like hysterical or maladjusted in legal briefs, reflecting a trend where the courtroom became a theater for amateur psychoanalysis. As the decade progressed, the divorce attorney's stage expanded from the suburbs to the bright lights of Hollywood and New York City, giving rise to the first true celebrity divorce attorneys. These were men like Jerry Giesler, who understood that in the age of television, the courtroom was just one of many arenas where a case could be won. Giesler and his contemporaries recognized that the press could be used as a high-pressure lever. If a wealthy husband was refusing a fair settlement, the attorney might subtly leak details of his private indiscretions to a powerful gossip columnist like Hedda Hopper or Luella Parsons. This created a potential outcome where the husband would settle for a massive sum just to keep his name out of the headlines. This was the birth of the media-saturated divorce trial. The legal strategy shifted from proving a crime to managing a brand. The attorney became a publicist, carefully crafting the image of their client as a wronged, dignified martyr while painting the opposition as a villain of the highest order. The financial data of the 1950s reflects this professionalization. Legal fees for high-profile cases began to reach astronomical levels, with some attorneys charging retainers that would be equivalent to hundreds of thousands of dollars in 2026. This period also saw the introduction of the forensic accountant. As the American economy boomed, wealth became more complex, tied up in stock options, deferred compensation, and shell companies. The divorce attorney had to become a financial investigator, digging through layers of corporate filings to find hidden caches of money. This led to a step-by-step refinement of discovery techniques that are still used today. An attorney in 1958 might spend months tracking the flow of funds from a husband's business account to a secret apartment or an offshore bank account. The potential outcomes of these financial deep dives often resulted in settlements that far exceeded what a standard court-ordered alimony would have provided. One of the most significant historical trends of the late 1950s was the emergence of the battle over child custody. In the early 20th century, custody was often an afterthought or settled based on rigid gender roles. But by 1959, the concept of the best interests of the child began to take root in the legal lexicon. Attorneys started using children as pawns in a way that had never been seen before. They would hire private investigators to follow the other parent, not to catch them in bed with a lover, but to catch them being a bad parent, leaving the children with a sitter for too long, or being seen in a bar. This was a brutal shift in tactics. The attorney's job was to build a dossier of parenting failures. Imagine a scenario where a mother's attorney in 1957 would document every time the father forgot a birthday or missed a school play, using these minor infractions to argue for a total loss of visitation rights. This weaponization of the family unit changed the emotional landscape of the divorce attorney's office forever. It was no longer just a business transaction. It was a total war for the future of the children. This era also saw the first major challenges to the legality of the migratory and foreign divorces we discussed in earlier parts. By 1960, the Supreme Court of the United States had to step in several times to clarify the rules of jurisdiction. Attorneys found themselves in a constant state of legal flux, having to warn their clients that a Reno decree might not hold up in a New York court if the residency was challenged. This uncertainty was a goldmine for the legal profession, as it required constant appeals and secondary litigation. The attorney became a permanent fixture in the life of the divorcee, often handling the fallout of a single divorce for a decade or more. The case study of the Bobo Rockefeller divorce in the mid-1950s stands as a testament to this. It was a multi-year legal odyssey that involved some of the most powerful attorneys in the country and a record-breaking settlement of over $5 million. A sum that shocked the nation and solidified the image of the divorce attorney as the ultimate power broker. As we stand on the precipice of the 1960s, the world is about to change in ways that even the most forward-thinking attorney couldn't have predicted. The Cultural Revolution was coming, and with it, a total dismantling of the fault-based system. But before we get to the era of no fault, we have to look at the final desperate gasps of the old guard. In the early 60s, a new type of evidence began to appear in the attorney's toolkit: the electronic recording. This was the era of the hidden microphone and the tap telephone. Lawyers were pushing the boundaries of technology and ethics to gain an edge, often walking a fine line between legal advocacy and criminal wiretapping. How did these early surveillance techniques forever change the way privacy was viewed in a marriage? And what happened when an attorney's own recording device captured something so scandalous that even they were afraid to use it in court? The transition from the 50s suburb to the 60s counterculture was paved with magnetic tape and secret photographs. We are about to enter the decade where the law couldn't keep up with the people, and the result was a legal explosion that would eventually lead to the greatest shift in American matrimonial history. The age of the high-tech shakedown and the moral collapse of the courtroom is exactly where we are headed next. The year is 1962, and the divorce attorney's toolkit has undergone a radical, high-tech transformation. We have moved beyond the simple hotel room raid of the 1920s and the paperwork shuffling of the wartime 1940s. Entering the early 1960s, the matrimonial lawyer has embraced the age of electronics, turning the private sanctuary of the American home into a legal surveillance zone. This was the era of the high-tech shakedown, a period where historical trends show that the line between a legal professional and a clandestine intelligence officer became almost non-existent. For the American public in 2026, the level of invasive technology used back then might seem primitive, but in 1962, the introduction of the miniaturized wire recorder and the induction coil changed everything. Attorneys were no longer just looking for a photograph of a cheating spouse. They were looking for a recording of a confession, a whispered insult, or a tactical admission of financial concealment. Imagine if you were a successful architect named Thomas Miller in 1963. You live in a sleek mid-century modern home in the hills of California. You believe your private conversations are just that, private. However, your wife has been consulting with a new breed of divorce attorney who specializes in mechanical evidence. Under the attorney's direction, a specialized technician has installed a bug inside your desk lamp or attached an induction coil to the telephone line in the basement. This device doesn't even need to be physically spliced into the wires. It simply sits near the phone and picks up the electrical vibrations of the conversation, recording them onto a bulky reel-to-reel tape machine hidden in a crawl space. This step-by-step infiltration of the home was the primary strategy used to bypass the increasingly high bar for proving fault. In a courtroom where a judge might be tired of seeing the same staged hotel photos, a crisp audio recording of a husband berating his wife or discussing a secret bank account was the ultimate leverage. The potential outcomes for a client in this era shifted dramatically based on the quality of their recording equipment. Case studies from 1964 highlight the legal battle over the admissibility of these mechanical ears. At the time, federal law under Section 605 of the Communications Act of 1934 prohibited the interception and divulgence of wire communications, but many state courts were still operating in a gray zone. An aggressive attorney would argue that as long as one party to the conversation, the wife, consented to the recording, It wasn't an illegal wiretap but a recorded recollection. This led to a historical trend where the courtroom became a theater of playback. Imagine the tension in a wood-paneled room as an attorney hits the play button on a Grundig tape recorder, and the entire court hears the intimate, often ugly, details of a collapsing marriage. This wasn't just evidence. It was a psychological weapon designed to force a settlement. No husband wanted his professional colleagues or his children to hear those tapes, and attorneys used that fear to extract massive alimony payments and property concessions. Data from the early 1960s suggests that the market for private detectives specializing in electronic surveillance exploded. Firms that once focused on following spouses to restaurants were now hiring electrical engineers. The cost of a fully wired divorce operation could run into the thousands of dollars. An attorney's invoice from 1965 might include line items for frequency scanners, high-gain microphones, and tape transcription services. For the U.S. audience today, this reflects the beginning of the end of the expectation of privacy in domestic litigation. The attorney had effectively turned the marriage into a 24-hour recording session. This period also saw the rise of the psychological shakedown. Attorneys would hire psychiatrists not to help the couple, but to review the tapes and provide a diagnosis of mental cruelty based on the recorded outbursts. This was a sophisticated, if ethically dubious, way to meet the legal requirements of fault without having to prove physical violence or adultery. The moral collapse of the courtroom during this decade was a direct result of this technological arms race. Judges were becoming increasingly uncomfortable with their roles as voyeurs. The historical case study of the 1967 Florida Supreme Court case, Westerman v. Westerman, provides a perfect example of this friction. The court had to decide whether a husband's secret recordings of his wife's bedroom conversations violated her constitutional right to privacy. The fact that such a case even reached the Supreme Court level shows how prevalent these tactics had become. The attorney in that case was pushing the boundaries of the law, arguing that a wife had no expectation of privacy from her husband within the marital home. This aggressive stance by the matrimonial bar actually backfired, leading to a public outcry and a demand for more civilized legal standards. As the decade moved toward the late 60s, the legal profession faced a crisis of identity. The divorce attorney was seen by many as a parasite who fueled animosity for profit. This perception was backed by data showing that the average length of a contested divorce had doubled since the 1940s, largely due to the endless disputes over the admissibility of electronic evidence and the battle of the psychiatric experts. For a lawyer, the potential outcome of a long, drawn-out battle was a massive fee. But for the family, it was total emotional and financial depletion. This systemic failure created the perfect conditions for the most radical change in American legal history: the push for no-fault divorce. Attorneys were divided on this movement. The elite shakedown lawyers feared that no-fault laws would destroy their leverage and their lucrative fees. If you didn't have to prove fault, you didn't need the bugs, the detectives, or the staged raids. You didn't need the $5,000 forensic psychologists. On the other hand, a younger generation of reform-minded lawyers argued that the current system was making a mockery of the law, forcing people into perjury and rewarding the most devious participants. These reformers began drafting model legislation that would allow a marriage to be dissolved simply because it had suffered an irretrievable breakdown. Imagine the scene in a state legislature in 1969. On one side of the gallery are the old guard divorce attorneys, protecting their business model built on the ruins of privacy. On the other side are the reformers, pointing to the boxes of tapes and the folders of scandalous photos as proof that the system was broken beyond repair. This was a battle for the soul of the American legal system. The outcome of this struggle would determine whether the divorce attorney would remain a high-tech inquisitor or evolve into a professional mediator. The transition was not going to be quiet. As we enter the 1970s, the first no-fault laws were about to be signed into existence, most famously by Governor Ronald Reagan in California. But this didn't mean the attorneys went away. It meant they shifted their focus from who broke the marriage to who gets the money. The battle shifted from the bedroom to the boardroom, and the tactics became even more financially complex. But before we get to the era of the modern financial war, we have to look at the final, most scandalous case of the fault era. A case that involved a United States senator, a hidden camera in a flower arrangement, and a legal bill that exceeded the value of the estate itself. This case would be the final nail in the coffin of the old system. How did a single attorney's obsession with a high-stakes client lead to a total rewrite of the ethics code? And what happened when the very technology lawyers used to catch their clients' spouses was turned against the lawyers themselves? We are about to enter the era of the legal whistleblower, where the secrets of the 1960s matrimonial bar were finally spilled to the public. The next part of our masterclass uncovers the great unraveling, where the divorce attorney's secret world finally collapsed under the weight of its own scandals. We are moving toward the birth of the modern system, but the journey through the debris of the 60s is full of warnings for every professional today. The great unraveling began not with a courtroom explosion, but with the silent stroke of a pen on a mahogany desk in Sacramento. In 1969, Governor Ronald Reagan signed the Family Law Act, making California the first state to embrace no-fault divorce. This single piece of legislation sent shockwaves through the American legal system, effectively dismantling the multi-million-dollar fault-based industry that attorneys had spent the better part of 60 years perfecting. For the divorce attorney of 1970, the world had changed overnight. The private investigators, the hotel room raids, the induction coils on telephone lines, and the professional correspondence were suddenly as obsolete as a horse and buggy on a high-speed interstate. This shift represents one of the most significant historical trends in the history of the American bar, transforming the attorney from a moral inquisitor into a financial forensics specialist. To understand the gravity of this change, we must look at the step-by-step collapse of the old guard and the rise of a new, even more lucrative legal battleground: the valuation war. Imagine if you were a veteran matrimonial lawyer named David Harrison in January 1970. For 20 years, your success potential was determined by your ability to manufacture or uncover dirt. You had a Rolodex of the best detectives in the city. You knew exactly which judges would grant a decree based on a single grainy photograph. Suddenly, none of that mattered. In the new no-fault world, the court no longer cared who slept with whom or who was habitually cold. The only question that mattered was, how much is the estate worth and how do we split it? This was a traumatic professional pivot. Attorneys who had built their reputations on psychological warfare now had to become experts in the Internal Revenue Code and the nuances of community property law. The data from the early 1970s shows a staggering surge in divorce filings. In 1970, the national divorce rate was roughly 3.5 per 1,000 people. By 1975, it had climbed to 4.8. This wasn't just because more people wanted to leave their marriages. It was because the legal barriers to exit had been demolished. For the attorney, the potential outcomes for a client shifted from winning freedom to winning the house. This era saw the birth of the forensic accountant as the attorney's new primary partner. In the previous decades, the lawyer's right hand was a man in a trench coat with a camera. Now it was a man in a gray suit with a calculator. Case studies from this period, particularly in the wake of the 1970 California law, show that the average legal bill for a high-net-worth divorce actually increased after the removal of fault. Why? Because while you could no longer argue about adultery, you could argue for years about the valuation of a private business, the appreciation of real estate, or the future value of a pension. One of the most profound historical trends during this transition was the death of the Reno divorce. Once California and subsequently other states adopted no-fault, the need to travel to Nevada for a 6-week residency evaporated. The Reno divorce mills, which had propped up the Nevada economy for half a century, saw their revenue plummet. Attorneys in these jurisdictions either had to shutter their doors or reinvent themselves as specialists in complex multi-state property disputes. This was the era where the term matrimonial lawyer began to be replaced by the more sanitized and professional family law practitioner. The change in terminology reflected a desperate attempt to wash away the stench of the 1960s shakedown era and rebrand the profession as a legitimate branch of civil litigation. However, the transition was far from clean. In states like New York, the old guard fought the no-fault movement with everything they had. New York attorneys, who benefited from some of the most restrictive and lucrative fault laws in the country, lobbied aggressively to keep the system in place. They argued that no-fault divorce would destroy the fabric of society, but the historical record suggests a more financial motivation. Fault was where the money was. Without the ability to threaten a spouse with a public, scandalous trial, the lawyer's leverage was severely diminished. New York would famously remain a fault-only state until 2010, creating a bizarre legal time capsule where the 1920s tactics of hotel raids and professional witnesses continue to be used well into the modern era. The true scandal of the 1970s, however, was the legal whistleblower incident known in historical circles as the Scandal of the Seven. This involved a high-profile firm in Chicago that had continued to use illegal wiretapping and extortion tactics, even after the tides had turned. One junior associate, disillusioned by the firm's refusal to adapt to the new ethical standards, turned over a cache of secret recordings to the state bar. These recordings didn't just catch cheating spouses. They caught the attorneys themselves coaching witnesses to commit perjury and discussing how to bribe court clerks to assign their cases to friendly judges. This scandal was the final nail in the coffin for the old matrimonial underworld. It led to a total rewrite of the American Bar Association's model rules of professional conduct in the early 1980s, emphasizing a lawyer's duty to the court over their duty to win at any cost. Imagine if you were a character named John Smith in the year 2026, looking through the digitized archives of your grandfather's legal practice from 1972. You would see a fascinating step-by-step transformation in his billing records. In 1968, the bills are for detectives and photographers. By 1972, the bills are for actuarial experts and real estate appraisers. This is the moment the divorce attorney became a corporate litigator for the home. The battle moved from the bedroom to the boardroom. The lawyer's job was now to find hidden assets, the offshore accounts, the deferred bonuses, and the family trusts. This required a level of financial sophistication that the old-school divorce lawyers simply didn't possess. Many of the most famous names of the 1950s disappeared, replaced by a new breed of Ivy League-educated attorneys who treated a divorce like a corporate merger gone wrong. This period also saw the emergence of the prenuptial agreement as a standard tool for the wealthy. Now that the state had made divorce easy, the attorney's role shifted toward prevention and protection. If the law wasn't going to make it hard to leave, the lawyer would make it expensive to leave. The historical trends of the late 1970s show a massive increase in the filing of these agreements, which were often drafted by the same attorneys who would later litigate their validity. This was a masterclass in risk management. The attorney was no longer just the person who ended the marriage. They were the person who defined the terms of its potential collapse before it even began. As we move into the 1980s, the world of the divorce attorney is about to enter its most extravagant phase. The era of the billionaire settlement and the celebrity superlawyer is on the horizon. But before we get to the glitz and glamour of the Reagan-era divorces, we must look at the dark undercurrent of the late 70s, the rise of the child snatching epidemic. Because the law had simplified the end of the marriage, the battle over the children became the new primary venue for high-stakes conflict. Parents, often coached by their lawyers, began to vanish with their children across state lines, leading to a new federal law that would once again change the game. How did the divorce attorney manage a case when the client and the children were thousands of miles away? And what happened when the FBI became a regular visitor to the family law office? We are moving from the valuation of assets to the valuation of a human life, and the tactics used are some of the most controversial in legal history. The era of the fugitive parent and the interstate legal war is what we are uncovering next. The interstate legal war that erupted in the late 1970s and early 1980s was the direct result of a fragmented American judicial system that had not yet accounted for the high mobility of the post-war population. To understand the divorce attorney of this era, you have to imagine a world where state lines acted as magical barriers that could effectively dissolve the power of a court order. This was the age of the fugitive parent, and for the matrimonial lawyer, it was a period of high-stakes, cross-country maneuvering that often skirted the very edge of criminal conduct. Before the federal government intervened, if a parent was dissatisfied with a custody ruling in New Jersey, their attorney might subtly suggest that the legal climate in a state like Georgia or Nevada was significantly more sympathetic to their specific situation. This created a historical trend known as the jurisdictional race to the courthouse. The strategy was simple but brutal. Snatch the child, move to a new state, establish a residency marker, and file for a fresh custody hearing before the home state could react. Imagine if you were a mother named Linda Carter in 1978. After a grueling 2-year legal battle in Chicago, you are granted primary custody of your 2 children. Your ex-husband, a man with significant financial resources and a high-priced litigator, arrives for his scheduled weekend visitation. He doesn't return. By Monday morning, you discover he has crossed 4 state lines. In 1978, your Chicago attorney would have to explain the grim reality. The Illinois court order had no inherent teeth in Arizona. To get your children back, your lawyer would have to hire a local counsel in Arizona, file a writ of habeas corpus, and pray that the Arizona judge respected the principle of comity, the voluntary recognition of another state's laws. However, historical trends show that many judges, fueled by a misguided sense of local protectionism, would simply reopen the case, allowing the fugitive parent a second bite at the apple. For the attorney, this was a massive revenue generator. You weren't just litigating one divorce. You were litigating a series of interconnected battles across the American map. The data from this period is staggering. By the turn of the decade, it was estimated that upwards of 100,000 children were being moved across state lines annually in violation of custody orders. This social crisis led to a radical shift in the legal landscape with the passage of the Parental Kidnapping Prevention Act of 1980, or the PKPA. This was a masterclass in federal overreach designed to save the state court systems from themselves. The PKPA, combined with the Uniform Child Custody Jurisdiction Act, or UCCJA, established the home state rule. This rule dictated that the state where the child had lived for the last 6 months had exclusive jurisdiction. For the divorce attorney, this changed the step-by-step mechanics of the custody battle. The goal was no longer to run. It was to prove where the child truly belonged. Attorneys had to become experts in tracking school records, pediatric appointments, and playgroup schedules to establish a legal domicile. As the 1980s moved into full swing, the divorce attorney transitioned from the war room to the media circuit. This was the era of the celebrity superlawyer, personified by figures like Marvin Mitchelson. Mitchelson pioneered a historical trend that would change the U.S. legal landscape forever: the Palimony suit. The landmark case study of Marvin versus Marvin, involving actor Lee Marvin and his long-term partner Michelle Triola, established that even without a marriage certificate, an implied contract for financial support could exist. This was a legal earthquake. Suddenly, the divorce attorney's potential outcomes weren't limited to married couples. Every high-net-worth individual in a cohabiting relationship became a potential client or a potential target. The attorney's role expanded into the realm of contract law, arguing that the years of domestic service and companionship provided by a non-married partner had a quantifiable market value. This decade also saw the rise of the scorched earth policy in high-stakes litigation. In a 1984 case study involving a multi-million-dollar real estate developer, the husband's attorney utilized a strategy of financial attrition. The step-by-step process involved filing dozens of motions to delay discovery, moving assets into complex offshore trusts, and challenging the valuation of every single piece of property the couple owned. The goal was to exhaust the wife's legal budget until she was forced to accept a subpar settlement. This was the dark side of the 1980s boom. As the American economy expanded, the complexity of the marital estate grew. An attorney in 1986 had to manage a team of specialists: forensic accountants to trace junk bond investments, art appraisers to value contemporary collections, and even private security to protect clients during high-tension exchanges. The financial potential for these attorneys was unprecedented. Retainers for top-tier matrimonial firms in cities like New York and Los Angeles reached 6 figures, with hourly rates that would be equivalent to thousands of dollars in today's 2026 economy. This era also saw the birth of the prenuptial agreement as a standard requirement for the wealthy. Now that the law had made it easier to leave a marriage, the attorney's focus shifted to making it expensive to do so. They were no longer just cleaning up the mess of a broken home. They were designing the architecture of its potential destruction before the first vow was even exchanged. This proactive legal planning became a cornerstone of the professional's practice, creating a new historical trend where the lawyer was present at the beginning, middle, and end of the romantic life cycle. However, the ethics of the profession were under constant fire. The 1980s was a decade of excess, and the divorce bar was not immune. Case studies from the mid-80s reveal instances of attorneys being investigated for racketeering when they coordinated with private investigators to use illegal wiretaps, a carryover from the 60s that had become even more dangerous with the advent of the first portable cellular phones. The attorney had to be careful. The same tools they used to trap an opponent could now be used by federal agents to trap them. The shift toward a more regulated, ethical bar was slow but inevitable, as the American Bar Association began to crack down on the most egregious shakedown tactics. Imagine if you were a character named James Reynolds in 1989, a high-earning trader in Manhattan. Your divorce attorney isn't just a lawyer. He is a strategist who coordinates with your PR firm to ensure that when the news of your split hits the papers, you are portrayed as the stable, hardworking provider. This was the final evolution of the 20th century divorce attorney, the total brand manager. They understood that in the age of 24-hour news and tabloid dominance, the court of public opinion was often more important than the court of law. A well-placed story in a gossip column could do more to force a settlement than 10 motions in front of a judge. As the 1980s drew to a close, the legal profession was standing on the edge of a digital revolution that would make the wiretaps of the 60s look like toys. The first personal computers were entering the home, and with them, a new trail of digital breadcrumbs. The divorce attorney was about to move from the world of paper ledgers and physical surveillance into the world of metadata and deleted files. But just as the technology was advancing, a final massive scandal was brewing. One that would involve the highest levels of the American judiciary and a secret network of attorneys who had turned the divorce court into a literal marketplace for children and property. This final chapter of our historical deep dive will uncover the Great Purge of the 1990s and how the arrival of the internet changed the business of heartbreak forever. We are heading into the era where a single deleted email could cost a man $1 billion, and where the attorney's most powerful tool was no longer a camera, but a keyboard. The final part of our masterclass reveals how the past 100 years of legal theater finally collided with the digital age, creating the system we know today. The Great Purge of the 1990s was not a single event but a systemic cleaning of the American judicial house that finally sought to eradicate the lingering shadows of the early 20th century matrimonial underworld. As the legal profession entered the final decade of the millennium, the old guard tactics of the 1920s through the 1960s, the bribes, the staged raids, and the institutionalized perjury, collided head-on with a new era of federal oversight and digital transparency. To understand the divorce attorney at the dawn of the 21st century, we must look at how the transition from manila folders to hard drives fundamentally altered the potential outcomes for every litigant. The divorce attorney of the 1990s became a pioneer of electronic discovery, a field that transformed the keyboard into the most lethal weapon in the domestic arsenal. Imagine if you were a tech entrepreneur named Mark Stevens in 1996, living in the early boomtown of Seattle. You believe your private communications are secure because you have deleted your emails and cleared your browser history. However, your spouse has hired a new breed of matrimonial specialist, the digital forensic attorney. Unlike the 1950s lawyer who relied on a private eye with a camera, this attorney employs computer experts to mirror your hard drive and recover fragmented data from the slack space of your disk. The step-by-step process of a 1990s digital raid was revolutionary. The attorney would secure a court order for a mirror image of the family computer. They would then search for keywords related to hidden bank accounts, mistress names, or shell companies. This was the moment the legal ghost of the 1940s was finally caught by the digital footprint of the 1990s. The historical trends show that during this period, the value of information shifted from what could be seen to what could be recovered from a deleted file. The data from the 1990s reveals a paradox in the American legal system. While the divorce rate actually began to stabilize and even slightly decline for the first time in decades, the cost of litigation reached an all-time high. A case study of a high-profile 1994 divorce in New York City shows that the legal fees for a mid-level executive could easily exceed $200,000, nearly $400,000 in 2026 currency. This inflation was driven by the sheer volume of information that now had to be reviewed. Attorneys were no longer looking through a few boxes of bank statements. They were reviewing thousands of emails, pager logs, and early mobile phone records. The role of the attorney shifted from storyteller to data manager. They had to be able to synthesize vast amounts of electronic evidence into a coherent narrative of financial misconduct or hidden assets. This period also saw the culmination of the Great Purge in the judiciary. For much of the early 20th century, the matrimonial courts were seen as a backwater of the legal system, often overlooked by federal investigators. That changed with investigations like Operation Greylord in Chicago, which, while focused on the broader court system, exposed a culture of payoffs and favorable rulings that had infected the divorce bar for decades. Attorneys who had built their entire careers on knowing which judge could be influenced found themselves facing federal indictments. This was a critical turning point for the U.S. audience today because it established the modern expectation of judicial neutrality. The divorce attorney was forced to return to the merits of the law, rather than the depth of their political connections. As the world moved toward the year 2000, the divorce attorney began to tackle the final frontier of early 20th century litigation, the globalized estate. Historical trends show that as American wealth became increasingly international, the attorney's job became a complex game of jurisdictional chess. Imagine a character named Elizabeth Vance in 1998, whose husband had moved a significant portion of the marital assets into a series of offshore trusts in the Cook Islands or the Cayman Islands. Her attorney had to be more than just a family lawyer. They had to be an expert in international treaty law and the enforcement of foreign judgments. The potential outcomes of these cases often hinged on whether the attorney could successfully argue for a mar eva injunction, a legal freeze on assets that prevented the husband from moving the money again before the trial concluded. This was the high-stakes evolution of the 1920s shakedown, now played out across international borders with billions of dollars on the line. The step-by-step sophistication of these financial wars in the late 90s led to the birth of the super settlement. In 1999, the divorce of Rupert and Anna Murdoch set a new historical benchmark, with the settlement estimated at $1.7 billion. This case study served as a masterclass for the entire legal profession. It proved that in the modern era, the divorce attorney was effectively a corporate liquidator. They were no longer arguing about the sanctity of the home, but about the valuation of global media empires and the future control of multinational corporations. The attorney's strategy in these elite cases involved a massive team of co-counsel, tax specialists, and public relations experts, all working in a synchronized war room that would have been unrecognizable to the solo practitioners of the 1910s. However, for the average American family, the legacy of the early 20th century divorce attorney left a more complicated inheritance. The adversarial system created by the fault era remained the default setting for most courts, even under no-fault laws. The attorney still felt the pressure to win, which often meant escalating conflict rather than resolving it. This led to the final major historical trend we will examine: the rise of mediation and collaborative law. By the early 2000s, a significant movement within the bar began to reject the 100-year history of courtroom theater. These attorneys argued that the high-tech shakedowns and the digital raids were destroying families and depleting estates. They began to promote a step-by-step process where both parties and their attorneys agreed to stay out of court, focusing instead on interest-based negotiation and transparency. This brings us to the present day, 2026. Looking back over this 10-part deep dive, we can see a clear through line from the hotel room raids of the Gilded Age to the sophisticated cyber-tracking of the modern era. The divorce attorney has evolved from a social pariah and a fixer into one of the most powerful and technically skilled professionals in the American legal system. They have transitioned from the matrimonial underworld to the top floor of the tallest skyscrapers in the country. But the core of the job remains the same: navigating the collapse of the most intimate of human contracts. The history of the divorce attorney is the history of America's changing relationship with morality, money, and personal freedom. As we conclude this masterclass, it is clear that the legal landscape is once again on the verge of a total transformation. The arrival of artificial intelligence and automated legal drafting is already beginning to replace the high-volume work of the 1980s and 90s. The next decade will determine if the divorce attorney remains a necessary strategist or if the business of heartbreak will finally be turned over to the algorithms. But to understand where the law is going, you must never forget the hotel room in 1915, the desert ranch in 1927, or the hidden microphone in 1962. These are the foundations of the billion-dollar industry that shapes the American family today. But even as the digital age matures, a new and even more complex frontier is emerging. One that involves the legal ownership of genetic material, the division of digital consciousness, and the jurisdictional rights of the first lunar colonies. If you thought the battle over a 1920s estate was complicated, wait until you see how the next century of matrimonial law will handle a world where forever has a completely different definition. The evolution of the attorney is far from over. It is simply moving into a realm where the laws of physics might matter as much as the laws of the state. We are preparing to explore the future of the fracture in our next series, where the stakes are no longer just your home, but your very identity.